Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. I'm Shamika Rhymes, and today we're talking about what happens when the defense stops focusing on the incident itself and starts attacking the plaintiff's character. Welcome back, Kiernan.
Thanks for having me, Shamika. Great to be here.
Well, Kiernan, in serious injury cases, what usually signals that the defense is shifting away from liability arguments and toward attacking the plaintiff personally?
I take it very personally myself when defense lawyers try to get into personal attacks on the plaintiff. I think that you can make anybody look like a liar at least a little bit if you try hard enough. And it's part of my job to stand up for good people and make sure that they're treated fairly and with respect in a courtroom. So sometimes defense efforts to portray my clients in a bad light gets a little bit ugly, but I am not going to let these things happen if I have anything to say about it. So in terms of when things shift to focusing on the plaintiff's character, I'd say it's not an either or. Liability and character are separate axes they can defend on. And if they can try to bring the plaintiff's character into it, then they will. Character attacks are dangerous to make. Sometimes they work, sometimes they don't. Sometimes they wind up helping us out. An attorney experienced with trying cases like myself where this is an issue can give you a lot of insight if you're not used to handling these types of cases or you have a case that's more high stakes than you're used to.
What kinds of background issues or life details do defense teams most often try to reframe as credibility problems?
It could be almost anything, but in my experience, the biggest landmine is the victim's personal medical history. One time I was really bored in a deposition that I was presenting, and I asked myself, hey, if I had to respond to an interrogatory where I had to give 10 years of medical history and say every doctor I went to, why I went and what they did, I wouldn't be able to do it. Like, nobody remembers that. And it's important that things like lack of memory, especially when nobody would really remember what they're being asked about, doesn't get framed as stonewalling or hiding the ball or any kind of dishonesty. At my firm, we prep clients carefully on medical history and up and down the line for depositions. Deposition preparation is something I've spent a ton of time on in my career. There's different ways to approach it. Some lawyers will prep a client for only 15 minutes. This is the authenticity maxing approach. They want their clients to seem as natural and non-coached as possible. Some lawyers will do 2 days. I've never done that, but I do know some lawyers who do it. I have my own system, and what I find works best is I'm rarely surprised by what defense lawyers will do. So I generally want to spend a little more time preparing my client than the other side's going to spend taking the deposition. So if I'm expecting a 3-hour deposition, I might spend 4 hours, 4 hours and 15 minutes, something like that. Authentic is best, but we still need to make the plaintiff feel comfortable with the question and answer format, and we want to anticipate the trick questions that'll come up.
Well, how do character attacks tend to enter a case procedurally through pleadings, discovery requests, depositions, or expert opinions?
2 ways are the most common ways. The first way is they do a bunch of private digging first. They go on the web, they search social media, they make background checks, maybe they hire a private investigator to follow the victim around for a while, and then they ambush the victim, my client, at the deposition with whatever they've found, oftentimes without providing the materials to us beforehand, which we don't ever let them do. We'll stop the deposition and require them to provide it, whatever they got to us, so that I have a chance to look at it and prep my client on it. But sometimes they'll try to ambush you in the deposition with stuff that they didn't get through discovery requests. Then there's the other way, that this happens where they'll ask a bunch of questions in the deposition first, and then they'll subpoena documents, and then they'll hunt for inconsistencies. I'd say those are probably the two main ways. Through experts, like sometimes, especially in like a brain injury case, they'll have an expert try to say that the plaintiff is malingering or exhibiting like symptom magnification, but that we usually see that coming a mile away.
Wow, I had no idea they were digging on social media and hiring private investigators. Well, can you walk us through a case where character smears became a central defense theme, even though they had little to do with how the injury occurred?
The most common smear that I see is actually on the lawyers. One thing they'll try to do to mitigate some of the bad optics of attacking the plaintiff's character is they'll attack the plaintiff lawyer. They'll often say that medical treatment is lawyer driven and the doctors have no more credibility than the lawyer, and that the whole thing isn't real and it's just for money. So they'll come after the plaintiff lawyer rather than just the client. And I've seen that in 12 plus closing arguments before, at least. I fight tooth and nail over this at trial. And if anybody has questions about how to handle those types of tactics, I'm happy to answer them.
Well, since we were just talking about social media a minute ago, how do social media, prior medical history, or employment records get used to quietly reshape the jury's perception of the plaintiff?
Yeah, I think social media is really the big one that we need to talk about because there's something really interesting about this. Like, social media culture encourages people to put their best foot forward online.
Yes.
Nobody
Uh-huh.
posts when they're tired, depressed, hurt, looking bad. And, people typically, even like we probably all know somebody who's trying to make their life look great on social media when we actually know what's going on with them. We might know more people than just one that do that.
Mhm.
So what the defense hunts for is like ways to capitalize on that, because typically people aren't just trying to present normality on social media. They're actually trying to make themselves look good. So they hunt
Yeah.
for any kind of inconsistency that they can find with how the plaintiff is describing their injuries and what they're presenting to their followers on social media. And I mean, I've seen examples of this on both opposite ends of, the spectrum, like both extremes, where like somebody's claiming in a lawsuit that they had a permanent back injury, and then defense finds an Instagram video of them like military pressing their girlfriend over their head.
Oh my goodness.
True story. And I've also
Wow.
seen defense counsel try to claim that a Facebook photo of somebody smiling somehow implies that they're not hurt, or as if somebody who's been injured is incapable of smiling for the camera. But just
Mhm.
generally speaking, I always advise my clients to stay off social media as much as possible, because like the incentives, like I've been saying, of social media are not just look normal, look good, look better than you're doing. So
Mhm.
that's not helping in a lawsuit. In the thousands of PI cases that I've closed, I can only think of one case where I thought that the client's social media presence was actually helpful to them.
Well, where do these character-based strategies tend to overreach, and how does that overreach start to undermine the defense's position?
Absolutely. Like, so this is the silver lining of the whole ordeal when it comes to like defense efforts to portray a plaintiff as a liar, a cheat, and a fraud. Juries are usually, not always and not in every case, but juries are usually pretty good at judging character. Like, juries are generally pretty good at knowing who's telling the truth and who's not. So when we've got a plaintiff who is credible, who is believable, who's honest, even if their testimony isn't completely flawless on every point, the jury's going to know that that's a credible person, and they're going to believe them. So the lawyer arguing that they're not believable or that they're lying or, motivated by, financial gain, it's often not enough to move the jury. And it starts to backfire when the jury can tell that the defense is trying to make an honest person look like a liar. And this is stuff that we have to think about too. I mean, there's only so much I can villainize somebody who's going to be sympathetic to a jury, and I'm mindful of that. And any good lawyer is going to be mindful of that. So, smart defense counsel won't push those buttons unless it's really warranted. And, I don't either.
Well, how would you say that judges typically respond when character evidence starts pushing way beyond relevance into prejudice?
I think this is another good bit of silver lining, because I find in my experience today, judges handle these kind of issues really well during pretrial. If a particular line of questioning or a particular piece of evidence doesn't serve any relevant purpose, and somebody's just trying to get it in just to make somebody look bad and for no other reason, that evidence will often be excluded by the judge. Sometimes things come up during the trial that wasn't covered in pretrial, or that just somebody discovers something and there's a surprise in the case. The problem with that is that the jury can't unhear it. So, I mean, the judge can tell the jury to disregard it. The judge can, strike it from the record. They still heard it. You can't unhear it. You can't get the skunk out of the jury box is an old saying. So when that happens, it's very important for me, as the person who's responsible for making sure that the jury gets it right and isn't distracted by red herrings and bad faith tactics. Sometimes we wind up in situations where we have to trust the jury to know fact from fiction. And I think juries are generally pretty good at that.
Kiernan, I look forward to every time we record and you drop some kind of phrase that I've got to use later on. So I like that. The skunk out of the jury box. You can't, okay, I like that. So what role does deposition framing play in locking in or neutralizing character attacks before trial?
Yeah, with depositions, I mean, the number one rule is the first thing you hear anybody say when the deposition starts, which is, you swear to tell the truth. Like, answer honestly. And honesty includes, I don't remember and I don't know. And it's easy for a person who's never been in a lawsuit before to feel like they're in school taking a test, and if they see a question on the exam and they don't know the answer, they're like, if you don't know or you can't remember, that's the only right answer. And a truthful deposition limits what the defense can do. If you tell the facts are the facts. Testimony is part of the process of knowing what the facts are, but a lot of cases have physical evidence, witnesses, other parties, investigative reports and things like that. So the facts are not necessarily established by what's in the deposition. So it's just important for witnesses to remember that if you tell the truth, you can't really get in trouble. I mean, not only is it the right thing to do, the truth is usually easier to remember.
As a case moves toward trial, how do you assess whether character smears will actually resonate with the jury or backfire once the full story is presented?
I would say the important thing is, don't be intimidated. I do not let myself be intimidated by these types of defenses. When we're right, and I know my client is an honest person and is telling the truth, and I know that I have evidence to back that up, I'm not going to bet that the jury misses that. So to some extent, the defense is going to do what the defense is going to do. And if I've got a credible plaintiff, if they're going to try to make my credible plaintiff look like a liar, good, because that's going to backfire, or the jury won't buy it. So, I mean, they picked the wrong lawyer to try to scare. And the real issue, like if there's a real issue in the case, like where there is a credibility issue, or that there is some sort of issue that we think that could be a problem, then we don't hide from it. We let it shape our strategy, and we serve the client the best we can.
Well, Kiernan, as always, this has been a super informative conversation. Thank you.
Thank you so much for having me. Great to be here and great to talk to you.
Well, that's it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. To learn more about attorney Kiernan McAlpine and his work at McAlpine Law Firm, visit McAlpineLaw.com. Thanks for listening, and don't forget to like, subscribe to the show, and leave a review if you found this episode helpful.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.